The importance of the ruling Solomon and why exceptions have evolved due to it. In the case of Salomon and Salomon, Mr. Salomon was a shoemaker. He converted his business into a limited company. His wife and children became subscribers. He was allocated 20,001 of the company's 20,007 shares. The company gave Mr. S 10,000 in debentures and received an advance of 5,000 in security of the debentures. The business eventually failed and then it went into liquidation. The remaining assets were claimed by Salomon under his retained debentures. This would leave nothing for his unsecured creditors. The company's liquidators argued that Salomon should be responsible for the company's debts. So the issue in Salomon was the formation of A. Salomon & Co. Limited a fraud intended to defeat creditors? It was held that after several sets of proceedings in the lower courts, the appeal landed in the House of Lords, which is now the Supreme Court. The Companies Act 1862 did not require shareholders to be independent of the majority of shareholders. A. Salomon & Co. Limited was legally constituted, and it was not the role of the judges to read limitations into the statute in a manner that they considered preferable. Lord Halsbury, at page 22, suggests either the limited company was a legal entity or it was not. If it was, the business belonged to it and not to Mr. Salomon. If it was not, there was no person, no thing to be an agent at all. And it is impossible to say at the same time that there is a company and there is not. And therefore the rule was established in Salomon. So the rule in Salomon. Part 2, Section 15 of the Companies Act 1993 codifies that a company is a legal entity in its own right. The doctrine of separate legal entity is a doctrine which has gained increasing importance in the analysis of company law. The importance of this doctrine and its relevance in the analysis of the laws relating to companies was articulately advocated in the case of Salomon and Salomon, the leading case which gave effect to separate entity principle. It created that the idea that companies operate behind a metaphoric veil of incorporation, which separates members from the company and permits the company to be completely independent with rights and duties distinct from those possessed by its shareholders, directors, and employees. The company is deemed an artificial legal person with independent existence. So, a principle reasserted in former cases. The Salomon case has been reaffirmed in many cases, even in cases such as Macara and Northern Assurance Company, where the principle was not in favour of the person creating the company. This doctrine also implied in the case where the principal shareholder, also being the governing director of a company, was held under this principle, able to make employment contract between his company and himself. This solution was one of the case Lee and Lee's Air Farming Limited, where a company was held to be able to employ one of its members under a contract of service. The current position of this doctrine has changed the attitude and has strengthened the Salomon principle with the case of Adams and Cape Industries. Since this case, it seems that only circumstances in which the courts are likely to lift the veil are, firstly, when the court is construing a statute, contract, or other document which requires the veil to be lifted. Secondly, when the court is satisfied that the company is a mere facade, so that there is an abuse of corporate form. And thirdly, when it can be established that the company is an authorized agent of its controllers or its members, corporate or human. However, there are still criticisms to this exception. So, the consequences of Salomon and Salomon. This principle is often cited in courtrooms, quoted in textbooks. It's basically become the basis of company law. Following the decisions of the House of Lords in Solomon's case, it established that upon incorporation, the company acquired certain attributes such as separate legal personality, limited liability, the right to sue and be sued, amongst many others, which may or may not be advantageous to its existence as going concern. Some of the advantages and disadvantages will be discussed further on, which will then lead to the exceptions to the rule established in Salomon. The principles separate legal personality and limited liability have raised questions because they are formulated on the basis of general reasons for not applying them, such as fraud, the company being a sham or facade, that the company is an agent of a shareholder, that the companies are part of a single economic unit, or even that the interests of justice required as a result. So what is piercing or lifting the veil, and why has it occurred? So the doctrine of lifting the veil of incorporation admits the fundamental possibility of imposing liability for a company's obligations to its controlling person. There can be an opposite situation when the penalty for a person or entity is drawn to the assets the company under control. Sometimes shareholders himself requires like piercing the veil of incorporation. This usually it concerns not obligations but the rights of company which shareholders wish to have. So the courts, they've always been wary that there must be some limit to the protection afforded by limited liability in order to ensure that the business dealings remain honest. Thus, the concept of corporate veil exists due to the landmark decision established in Salomon. As well as that, just a free market economy relies upon the role of limited companies. It also relies on a degree of fairness in the dealings. This was recognised in the dicta of Denning, Lord Denning in Lazarus Estates Limited and Beasley, where he said at page 7112 that no court in this land would allow a person to keep an advantage which he had obtained by fraud. No judgment of a court, no order of a minister can be allowed to stand it if it has been obtained by fraud. Fraud unravels everything. The court is careful not to find fraud unless it is distinctly pleaded and proved. But once it is proved, it vitiates judgments, contracts, and all transactions whatsoever. Some statutes expressly authorise lifting the corporate veil. For instance, Section 213 Insolvency Act 1996 states that a court may ignore the corporate veil if, during winding up a company, it appears that the company's business has been carried on with intent to defraud its creditors, etc. However, there must be evidence of dishonesty, and there is like a high burden of proof, etc. So therefore, this is a very narrow exception. Under Section 214 Insolvency Act 1986, a company director may be liable for wrongful trading if they continue to trade, and they ought to have known that there was no reasonable prospect of avoiding insolvent liquidation. So there's no need for any dishonesty. However, this only applies to directors, not shareholders. The Companies Act 2006 also makes no mention of lifting the corporate veil. Therefore, Parliament has not significantly widened the exceptions to Salomon in recent years. So why were the exceptions evolved? So it is the previous statement of principle that underpinned all of the early attempts to pierce the corporate veil. The court would not allow the corporate personalities to be used to protect individuals from wrongdoings. Fraudulent actions would not be protected, nor would those the limited companies were simply being used as a facade or a sham. In the case of Guildford Motor Co. Limited and Horn, the court found that the veil of incorporation may be lifted in instances where there is evidence of a fraud. It is important to emphasise that the burden of proving fraud is a heavy one, and that allows the court to basically interfere with the corporate veil simply to prevent unjust results. This was acknowledged by Lord Keith of Kinkelly, Wolfson and Strathclyde Regional Council, where he commented at page 96 that it is appropriate to pierce the corporate veil only where special circumstances exist indicating that it's a mere facade considering the true facts. So is this facade the most established and reputable one? Well, Munby J's implicit view that piercing the corporate veil should only happen when no other remedy was available. So this does suggest that the facade theory is the most reputable one out of the rest of the exceptions, and it is the only one that is used considerably more than the other ones. However, in Ben and Hashem, Munby J stated that control and ownership of a company were not enough, nor was it sufficient to evoke necessity in the interest of justice. There needs to be some impropriety which must be linked to the use of the company structure to avoid or conceal liability, and therefore they must misuse a device or facade to conceal the wrongdoing of the controllers or owners. So, criticisms of the facade theory. In his recent Hamlin lecture, Lord Cook suggests that A. There is only one broad class of case where the case in lifting the veil are consistent with the Salomon reasoning, and B. The sham or facade exception to Salomon itself is a sham, and that's unneeded and unsound. So, the corporate veil test clearly is not fair, and While the legal position treats both types of shareholders, that is, parent companies and natural persons, equally by providing the same legal protection, the different nature of the two works to favour corporate groups. Without clear guidance as to when corporate group structures constitute a mere facade, corporate groups are practically free to operate however they please. The effect of the current position is to allow corporate groups to shift risks to overpower or involuntary creditors, thereby running serious risk of corporate group externalizing liability and negligence. This runs contrary to recent calls for greater corporate social responsibility and is clearly not desirable. To summarize, the separate legal personality is the basic tenet on which company law is premised, establishing the foundation of how company exists and functions. It is perceived as perhaps the most profound and steady rule of corporate jurisprudence. However, this rule has experienced many criticisms and is one of the most litigated aspects within and across jurisdictions, thus raising the exceptions such as the sham theory. However, the principle established in Solomon is still very much prevalent and forms the core of the universal commercial regime.